Hello everyone and welcome to our first lecture in Chapter 12, our second chapter in our unit on the judicial branch. And in this lecture, this one's going to be closely linked to the last lecture in Chapter 11, 11.3 on the Supreme Court. So in this one, we're actually going to take a look at Supreme Court at work and how they actually do their jobs. All right, so let's go through the procedures first. Now you guys need to understand that when the Supreme Court judges are on the court, they actually serve terms, but it's not like a term like you would think of like a president or like a Congress member. Their term begins when the year begins, and the judges will actually sit on the bench for 2 weeks a month, roughly, when they're actually doing their job and like trying cases. And then the other parts of the month, they're doing other things such as, writing opinions and looking at other cases and discussing them and so forth, but they're not actually sitting on the court for those 2 weeks. Now the sessions, they listen to arguments and announce an opinion. So when they're actually in session, they listen to the actual arguments in court, we'll go over that a little bit, and then they announce the opinion on the case, so the ruling. Generally, to decide on cases, they meet on Wednesdays and Fridays, and it's pretty straightforward. Wednesdays to kind of split up the week, and then Fridays to kind of end the stuff for the week that they're deciding on, and then that way they can start the next week fresh. Now when they're on recess, so those other 2 weeks of the month or 3 weeks of the month when they're not actually sitting on the court, they're working on paperwork, considering arguments, studying different petitions and stuff on the cases they're working on, and then also other cases, and then they're working on an opinion, so writing their explanation for why they voted or why they ruled one way or the other. Now guys, just to give you an example of how much work they actually look at during a given year. So this is about 20 years old, but in 2000, they had about 8,900 cases, a little over, and it's roughly around that now, that were brought to the attention of the Supreme Court. They reviewed only about 1% of those total cases, and they only ruled on 83 over the course of the entire year. So even though there's a lot of cases that get to them, there's not a lot they even consider, and there's even less so that they actually give an opinion on. All right, so how do they reach the Supreme Court? There's actually 3 ways they do, and when you guys get the actual PowerPoint version of this, you guys feel free to please click on that link to the video and watch it. It'll give you a little bit of basis, better understanding of how they reach the court. But there's 3 ways a case can actually get there. There's through original jurisdiction, so just a new case, something that hasn't been tried anywhere else. There's by writ of certiorari, or just shorten it up and call it writ of cert, or there's cases that get there on appeal. Now, typically the main route for a case to get to the Supreme Court is through the writ of cert. And basically what it is, it's an order to send up case records to review them, and then the court is free to choose those cases based on reviewing those records. About 90%, give or take a few percentage points, get rejected, depending on the case and depending on the given year and the makeup of the court. Now, if they choose to deny, and this is an important thing you guys need to understand, if they ever choose to deny, whether it's the writ of cert or anything else, a case, that lower court's decision stands. So whatever the last court to make a decision on it, that's the ruling that stands. The other way they get there, if it's not by writ of cert, it's typically by appeal, and these are just decisions that are up for review based on previous rulings, and then they're looking at something, whether it's constitutional or not, or dismissing and whether it violates, whether it's state law or federal law or both. All right, so we're going to talk about the Solicitor General here. This is actually a picture of an older Solicitor General under Obama, so I apologize for not updating the picture, but about half of the cases that the Supreme Court tries involve the federal government. So the federal government needs a representative, and that representative is the Solicitor General. They're appointed by the president, and the purpose of the Solicitor General is to do 2 things. It's to represent the federal government in these cases, but also to provide a link between these 2 branches, so the executive branch and the judicial branch. Now, generally, they're expected to support the president because they're appointed by him, so they're going to kind of supposed to take heed what the president wants them to do, but they also do other things too, such as helping set up the court's agenda in terms of cases that are going to be tried, and then determining if the federal government should appeal the decision or not. All right, so let's get to case selection, guys. I'm going to tell you right now, you're going to want to star this part in your notes, just so you understand. Okay, this is how case gets to the Supreme Court. So first off, justices or clerks of those justices decide on which cases need to be up for consideration. So what you should even just talk about possibly selecting. From there, the Chief Justice will put all these cases together on what's known as a discussion list. And this discussion list includes all the justices, and roughly about 2/3 of all the petitions that are made don't even make it to this list. Then they take the review list and this discussion list and they go through it. Typically they do this on Fridays, not always, but they usually do it on Fridays. Obvious reason, so that they can set up what they're going to be doing for the next week. And then as they review it, justices have time to review the cases. They'll actually present the reviews, whether they should move it along and possibly use it to be a case that's selected, or say, look, this isn't something that we need to even consider. And then 5, they'll do an acceptance. So if they usually use the rule of 4. If 4 of the 9 justices accept the case to be moved on, they'll accept it. And then generally what they'll do is they'll ask for more information to see if they can make a quicker ruling. Okay. Now next is a per curiam opinion. This is actually an unsigned statement of decision. This is actually used in a ruling without consulting new information. Generally they're used, the Supreme Court can look at it and say, okay, look, we feel like we have everything we need. Boom, here we go. We're going to put this decision out there. They don't sign it and they don't ask for any new information. All right. So this one, guys, also star this in your notes. So we're actually going to look at the procedure here, 1 through 4. There's going to be sections on the next couple of slides on each of these 4. So you don't have to write these down specifically in your notes because we'll be going through them. So first step in the procedure is submitting of briefs. So both sides do this, or if there's more than 2 sides, you'll have outsiders that possibly can put briefs in too. But brief is just a legal argument of support for their position. You might actually see friend of the court briefs or amicus curiae briefs, which are parties that aren't involved directly in the case may submit briefs. This could come from, an individual person, which is rare, all the way up to, corporations and so forth that may have a stock or say in what's going on. It could kind of come from everywhere. Second part is oral arguments. This is actually where the lawyers present their actual argument on the case. They're only allowed 30 minutes to do this because of the heavy workload of the Supreme Court they want to move through. And justices can actually challenge the argument. It's more of like almost like a question and answer session with the court in front of them. And how they do this is the lawyers will actually present from a lectern, as you can see here. And they're actually given a specific rule set with those 30 minutes. They'll actually get a white light that flashes towards them that gives them a 5-minute warning. Basically, hey, you need to start wrapping up your argument. And then a red light will say, hey, you need to stop immediately or you can be held in contempt. All right, so number 3 is the conference. So this is actually where the Supreme Court justices come together and they discuss the cases. Again, they typically do this on Wednesdays and Fridays. They debate the case and they don't take any minutes. So they don't take any notes about what they're talking about. The real reason for this is so that they can just say how they feel and not have people lash out at them for having an opinion that may be viewed as kind of, not really acceptable or controversial. So that way people can just be open in their discussion and debating the actual case. Now, how this usually goes about is the Chief Justice is the actual one that starts it, goes over a summary of the case, and gives recommendations. Now, generally, because of the heavy workload of the cases, again, this discussion is limited to 30 minutes to an hour, generally, so they can move through things as much as possible. But in important cases, they will take their time. And then they'll give a future discussion towards the end on about, or give a discussion at the end about future cases and saying, hey, look, these are possibly ones that are going to be coming down or ones that we're going to be talking about a little bit later. Now, generally from there, they go by seniority, and then each justice presents their conclusions, and then they vote. Everybody has an equal vote. Okay, so the Chief Justice or senior members don't have a higher weighted vote than the newer members of the court. Now, majority vote is generally votes with at least 6. If there's a tie, then the lower ruling will actually stand, because judges can abstain, or if you have an open position and they're trying to still push a case through, they can vote on it. But generally, you're not going to have a tie, but it does happen every once in a while. But if that, again, that's just like if they denied a case, like we talked about here. A tie makes the lower court's decision stand. All right, then lastly, we have the writing of the opinion. This is basically where the justices, whether it's the Chief Justice or every other individual one, regardless of which side they go on, if they're for or against the case, they write their opinion on the case and their explanation of the ruling, their reasoning for it, the facts of the case, and so forth. Each major case gets at least one opinion. The biggest cases in our country, they get multiple. In some cases, every single justice has written an opinion on it. And generally, the reason why they do this is not just to explain the reasoning by the court, but it's also to set precedent and as a way of communication for the court with the nation. So that, let's say, for example, in the setting precedent part, there's cases that come down the line that are very similar. Well, you could look back to this case and say, okay, we don't need to try this new one in the Supreme Court. We can go off of this ruling or look at this interpretation and kind of move through that. Now, there are 4 kinds of opinions. There's a unanimous decision, so where all the justices vote one way. There's a majority opinion where you have, whether it's 5 or more, justices vote towards a certain position, and they're all really on the same level, so they vote for the same reason. You have a concurring opinion, which you may have, let's say, 6 justices vote for, let's say Brown versus Board of Education. 6 justices vote to end segregation, but 3 have opposite reasons than the other 3 for ending it. And they're agreeing for other reasons, but they're on the same side ultimately. And then 4 is the dissenting opinion. This is the losing justices. So the justice or justices, if they lose, they may write their opinion explaining why they viewed or ruled in this way as well. Against what the majority of the court ruled. And that's important as well because it also does this too. It helps set precedent and provide communication and can be used later on. All right, last one here. So the opinions, generally the Chief Justice or senior majority justice, if the Chief Justice doesn't vote on the winning side, will actually write the opinion. Opinions can be shared with the public, their public policy. And this is important because you can go and look at and review all these opinions if you want to. They're long and so forth, but they are reviewed, not just by the public and other members of government, but the justices will actually review them before they're published and then give comments and say, hey, we may need to change this, or it could, in some cases, very rarely actually lose support for that opinion and change somebody's mind. But that doesn't happen very often. But it can say, hey, look, you need to change this. It's more about a revision process before it does go out to the public. And this is why cases actually take so long, is the opinion has to be written as well. Now, once the decisions or opinions have been finalized, it's announced publicly. Okay, and that's important. It's even though they vote on it, you might know the vote, but again, things can change because of opinions and so forth. They don't actually announce things until they have officially made the opinion and got it done. All right, guys, we're actually not going to do this activity here because you guys aren't doing the guided reading this time around, so you do not have to worry about this. And then I did give you some video clips here just to kind of give you some process in terms of like what stuff's like in the court. This is actually the Supreme Court one, but be careful with this one. It's just a little bit, the nature of the actual movie is a little adult, but there isn't really any good clips out there showing you like how things go in the Supreme Court in terms of lawyers showing arguments. So you can watch that if you want, but you don't have to. These clips you do not have to watch if you don't choose to. All right, guys, that's all I got for you. Hope you learned a lot. Please, this is an important lecture, especially when you combine it with section 3 and chapter 11. Those are probably the 2 most important in this unit. All right, have a good one.